and the recording should have started now.
Excellent. Thank you so much, Zeke. And I want to start off by thanking Zeke and Ian Meher and all of the wonderful folks at the BPDA. Really, the relationship between Casseus Law and BPDA started many, many years ago, and it's really been a pleasure to support the postdoc community. Casseus Law has just entered into our 11th year in helping postdocs and really helping individuals obtain their permanent residence and also non-immigrant visas. So I've prepared a few slides that are basically informational. After that, we will open up the floor to Q&A, where I want you all to feel comfortable asking questions. So I'm going to start with the slides that we have prepared. So welcome, BPDA. And we always start off with a disclaimer. Basically, this talk is intended to convey general information. There is no attorney-client privilege during this talk, but as you know, if you do reach out to our firm, we will keep your information private and confidential. So Casseus Law has assisted well over multiple hundreds of clients. It's really been a pleasure to work with researchers, entrepreneurs, and individuals from research institutes all the way out to pharmaceutical companies. We really run the gamut of who we're able to help. Our clients come from many institutions locally, and we also work with individuals internationally. So our mission is really to assist individuals in obtaining their visas and permanent residence in the US. We have maintained a 100% green card approval rate. Of course, any firm that comes with an asterisk. So there are clients that we've had to refile their case after a denial, but we're proud to have helped people get their green cards even after a denial. So I have the pleasure of working with my brilliant sister, attorney Rachel Casseus. She's a Princeton University graduate, and she specializes in EB-1A, B, and NIW green cards. Sabine is licensed to practice in 50 states. I am Rachel Casseus, your host for today. I also specialize in national interest waivers, EB-1A and B, green cards, and we really help to counsel clients on their best course of action. So a lot of clients will ask, prospective clients especially will ask, am I qualified for a green card? So this really depends on the category that you're applying for. So we'll look at 3 different categories: the national interest waiver, the EB-1A, which is the extraordinary ability category, and the EB-1B, outstanding researcher category. And usually one of those 3 categories will work well for postdocs. A lot of clients question and ask, do I have to have a certain number of citations before I can apply for a green card? And really the answer is no. A lot of attorneys might tell you wait to apply before you have 200 citations, or you only want to have X number of citations before applying for an EB-1A. And we really don't believe that there is a set number, really, because the officer that's reviewing your case is not looking for a set number of citations. They just want to feel confident that you actually meet the criteria for the given category that you're applying in. So most people on this call are probably already eligible for a national interest waiver, which is that sort of easiest. And I don't want to say easy, because even the national interest waiver has gotten more difficult over the years, but it is really that sort of baseline of, is your work nationally important? Are you well positioned to do the work? And once immigration waives the labor certification, are you someone who, because of your skills, waiving the labor certification makes sense? I will tell people, you want to give yourself at least, I have in the slide 2 years of visa validity, but I will say, 2 years is going to make it so that you're not stressed going through the process, especially if you cannot get an H-1B while your green card is pending. And the reason why you want to give yourself 2 years of visa validity is because it is taking up to 12 months to get work authorization. So once you do your planning, speak with an attorney and ask them, am I in a safe position to apply for a green card? Because as many of you know, once you apply for a green card, you would not be able to extend your F1 or your J1 visas. Really, any visa type other than an H1 or an L1 will not allow you to keep your non-immigrant status once you apply for the green card. So ask any attorney that you speak to if they provide a free credential review. Casseus Law does provide free credential reviews to determine if you meet a green card and also a non-immigrant category. Casseus Law does do O1 visas. We also have colleagues that we work with who we can refer you to them if you would like an H-1B or really any other visa type. So we'll provide these slides, but you can take our free evaluation on our website. And just a tip to give you all right now, if you don't have a Google Scholar report and you are a researcher, please make one. Immigration does consider the Google Scholar reports, and I think they are helpful in just showing that your work has been cited. How long is it taking to get a green card? So this is a really common question. USCIS is not following a first come, first serve basis. This is devastating for a lot of our clients who've been waiting 1 year, 2 years for their green card. We are seeing even cases filed in June being approved in 2 months later. So that is to say, it's really just based on where your case is sent. And if you're lucky enough to get a good officer that is able to review your case quickly. So we are seeing averages, but the average is not really applicable. So I want you all to consider these timelines with a grain of salt because things can change quickly. As you know, during COVID, there was a huge backlog of cases and those are still being considered, but we are seeing a good 6 to 12 month timeline on the EB1A and EB1B, really because those cases can be premium processed. The NIW, I will say most clients are getting their green card within 2 years, 18 months to about 24 months. We have a handful of clients who are approaching the 36-month, and that is really, I guess, a failure of immigration because those cases should not have taken that long. So having at least 1 year of current visa status before applying for a green card is okay. But as I said in the previous slide, you really want to give yourself 2 years. So the green card is actually a 2-step process if you are filing in the US. And so many of you would probably be filing your green card from the US. And so that is called the adjustment of status process. So immigration reviews your form I-140 first, and the I-140 is proof of your work in the field. So that's the category of the NIW, the EB1A, EB1B. And so after they review all of your letters that you provide with your case, your peer-reviewed papers, if any of you have performed judging for journals, they're reviewing all of that information to see if you meet the criteria. And then once your I-140 is approved, that's where it's the second step of the 2-step process. So immigration then reviews your 485, which is really anything showing your current visa status, your past visa statuses, if you've ever had a work authorization card. These are all of the things that you would put in with your 485. And our office helps compile all of these documents. So it's nothing that you need to memorize now. And once they're doing the review of the 485, you would also get scheduled for a biometrics appointment, which actually happens earlier in the process. But I mentioned biometrics just so that clients know that they will be taking fingerprints at a local USCIS office, which is in Revere. And that goes in as a background check to ensure that, you are a person who has kept a clean record. So the two-step process can actually be filed concurrently for people who a green card is available for. And that is actually determined by the visa bulletin. So monthly, you can see if the green card is current in your category. So for most people, the EB1A and B are current. And actually in December, the national interest waiver is not current. So the priority date is December 1st, 2022. So we are going to keep people updated about when they'd be able to file a green card again in the NIW category. But for now, because it's December 1st, no one on this call would have their case in. But that changes quickly. So Department of State will put out a new visa bulletin by the mid December, and we'll let you know what dates are available for the 45. So let's talk about the national interest waiver. I love the national interest waiver. It's a self-petition, meaning that you don't need a job offer or an employer to file your case. You can base your work, your application off of the current work that you're doing. So I would say about 90% of our cases are national interest waivers because it is a very generous standard. It's not asking you to be, the Einstein of your field like the EB1A or even outstanding like the EB1B. So you can apply really well on any status, but you do want to be in status, which most of you, I'm assuming, are. The common visa type that most people apply from would be F1 OPT, a J, H1B, TN. I mentioned the J waiver because if you are subject to 212E, which is the 2-year home rule, you would just need to waive the 212 requirement before applying for the green card. So the J waiver is not a status, but it is something that you will need if you're on a J waiver that's subject to the 2-year home rule. And our office helps to counsel people on how to get that no objection statement. The national interest waiver used to be faster than other employment-based applications. We left this line in really because that's subject to change. NIWs can really move quickly if the case is sent to an officer that has the availability to process your case. But there's no way of knowing how long it will take. So I always counsel clients that, there's no time like the present. If you're considering a green card, I would say file as soon as you're ready. There is a backlog for EB2 applying for the green card if you were born in China or India. So that is where the green card is not current. And for clients who are from China or India, we might recommend an EB1B or an EB1A to make use of premium processing and also that ability to apply concurrently for the green card. So the general requirements for the national interest waiver are found in the case matter of Donisar, which was a 2016 decision. And what this case did was sort of to expand the scope of who was able to obtain a national interest waiver. So we've actually done national interest waivers for architects, for entrepreneurs, for people who aren't scientists. And really, the beauty of this is that I think it allowed scientists with low citation numbers to have a better chance at getting a national interest waiver. Because once you prove to immigration that you are doing something that is novel or that is, moving the science forward, I think that is enough to get a national interest waiver by showing how special and important your work is. And then further, if you can show that your work is being patented or being used by other companies or being used in a clinical trial, that is also excellent evidence to provide to prove that not only is your work nationally important, but that it's also showing that you are well positioned to continue this work. And then that last prong of, doing the balancing test. Is it such that your work is so beneficial and so important to the US that USCIS should waive the labor certification requirements? And what labor certification is really, it's being used to protect US workers. So immigration will not grant a national interest waiver if there are available US workers who could do your same job. And really, this is where working with an attorney is helpful to help differentiate you from someone with, minimal skills or many US workers that could do the job. So this is why Casseus Law actually doesn't do national interest waivers. And I don't recommend them for people who are in sort of, an entry level work position, right? I really want to reserve this for people doing novel specialized work. So let's talk about some supporting evidence. And actually, this is relevant for even the EB1A or EB1B. So we do recommend that individuals update their CV, include all of your publications, presentations you've given. Try to keep your CV as current as possible. For the national interest waiver, I didn't explain the fact that you need an advanced degree or specialized knowledge. Most of you will have a PhD or a master's. If you don't have an advanced degree, you can prove that you have 5 years of experience in the field plus your bachelor's degree. Letters of recommendation are necessary to obtain your national interest waiver. I think 6 is sort of that magic number. And you want to start thinking of experts in your field who immigration could easily Google and say, okay, that person is an expert, so I believe that they're vouching for you, and this person seems credible. So I'm going to provide all of these slides. So we're going to breeze through these just so that we can get to your questions. I don't really see many people submitting media coverage for their national interest waivers only because maybe their work hasn't been picked up by a media source. And this is actually okay. You don't need to provide every piece of evidence that you see on this list. It's really something to help get you thinking. We do like showing grants from US sources. So a lot of clients, their work is funded by National Institutes of Health or USDA. We have some clients who have received DARPA funding, NASA funding, and it's okay that the funding isn't directed to you. Most of our clients, the funding is given to their PI, but we can include that you are working under US federal funds. So let's talk about the EB1A. Again, no sponsor and no employer is needed. However, these cases are highly scrutinized. So I don't recommend an EB1A for someone who cannot show that they are amongst the top expert in their field. Because USCIS has started to really pull apart these cases. They're issuing requests for evidence that are very long. And I think what ends up happening is that the officers are trained to see a very specific person and want to grant like only that person an EB1A. So I want to give you an example. Our last EB1A that was successful without an RFE was a woman who was working on planetary science and telescopes. So she was able to prove that with $1 million in her own funding, plus the fact that she had made some novel discoveries of galaxies, that this was enough to get her EB1A without an RFE. And because of the high dollar amount of her funding and also the discoveries, I think that, well, she had also done judging of journals. So she did peer review and reviewed manuscripts for publication. So those three factors were enough to push her over the edge to get the EB1A. But I've been seeing other cases where, the person doesn't seem as extraordinary. And so I think the cases that get the approvals are ones that immigration just feels very comfortable approving because they see the evidence is there. So this is to sort of caution people against trying for the EB1A, because I'm not seeing cases like that are reaches getting approved. And this is where in mid 2021, we actually decided to not do EB1As for people who didn't have, at least their own grant funding, or people whose work, just didn't seem to be applied, because I think immigration wants to see work being used by other people. Like citations, having thousands of citations is not enough. So in 2017, having 2,000 citations plus doing peer review for journals and maybe a few awards was enough to get that EB1A approval. But now in 2022, I don't think those same cases would have the same approval rates. So that is to say, talk to the attorney that you have chosen, to ask them, what are my chances of getting an approval? Because as you know, these processes are expensive. Premium processing for an EB1A is $2,500. I wouldn't want to see anyone lose that money just to try to get the EB1A. So that was a really long explanation. I hope I didn't scare anyone, but let's move forward to EB1B. This is a happier category. Why? Because immigration is really relying on your employer to prove that they want you to continue working for them. So EB1B is an employer-sponsored visa green card type. Excuse me. You cannot have an independent EB1B. So this means that your employer would be signing off on your I-140, that first step in the process. It does require that you have a minimum of 3 years related work experience in the field. And so most people will have a PhD before applying for the EB1B. So you can count the 5 or 6 years in the PhD toward that 3 years of experience. You do need to show that your employer has a distinguished reputation. A lot of our clients are coming from pharmaceutical companies and doing the EB1Bs. And this is sort of a future category for a lot of postdocs, right? Because not many institutes, really none, are doing EB1Bs for postdocs. We do have a small number of postdocs who have been able to get their institute to apply for an EB1B for them, but that was because these clients have guaranteed 5 to 6 years of funding, and their PI was ready to support them for the green card. You also need to show that your institute has at least 3 full-time researchers. So the EB1A and EB1B, in addition to you meeting the 2 out of 6 criteria for the EB1B or the 3 out of 10 criteria for the EB1A, you also need to show that once the immigration officer takes your case into consideration as a whole, does it establish that you are recognized internationally as extraordinary or outstanding? And so this is where a lot of cases can even fail, because even though the client has met 3 out of 10 or 2 out of 10 criteria, if you can't show as a whole that you are recognized internationally as extraordinary or outstanding, then you can lose your case. And so a lot of clients don't recognize that for the I-140, it is a two-step determination. So if USCIS determines that the evidence is not enough, they will request more evidence. So let's talk about some sample approved clients. Our client, Dr. An, actually had he had a doctoral degree. He was an MD. So this was enough to show the advanced degree. He also had a master's in pharmacology. He had 61 citations at the time of filing, and he was really doing some novel work on preventing strokes. So this is Rachel. She applied for an EB1B, and this was during the time that Beth Israel was doing EB1Bs for postdocs, which was very exciting. So if you are a postdoc, feel free to ask your PI if they'd be willing to support you on the EB1B. So she had 7 years of experience in platelet analysis. And as many of you know, platelets are vital for clotting and also lots of other important bodily functions. So we were able to show that her outstanding work in the field was of benefit to the field of platelet and analytical chemistry. So we, of course, this is a soccer player, but we wanted to protect the client who did not want to be named. So we had a EB1B researcher who actually created a drug catalyst that helped Novartis make $500 million. This client had done peer review for journals, had about 30 peer review. You don't need a set number of peer review. I would say 4 has been enough to get an approval, but you will need to provide the email asking you to perform the peer review in addition to the email thanking you for the peer review in order for it to count as peer review. Also, the peer review needs to be directed to you. It can't be review that your PI has asked you to do. So Dr. Jean was one of our clients from MIT. She had 134 citations at the time of filing. I actually don't think, as I said before, we've gotten clients with no citations approvals, but it is helpful to show that other people are using your work. And so she, at the time, was doing lots of great work on traumatic brain injury and doing making tools to simulate behavior of human tissues and organs. This is our NIW architect, and this is actually just to show you the fact that really there's no limit on who can get a national interest waiver. You don't need to be a scientist. So this individual, she had actually won government contracts to build affordable housing in Arizona. She had no citations, but she was employing US workers. So the next step, I would love all of you to update your resumes. If you are thinking of looking into getting your green card, you can already start by obtaining copies and translations of all of your documents that are not in English. You actually don't need to pay a translation company. You can do the translation yourself and then have a friend who is fluent in the language of the document and English, review your translation, and then sign a translation certification. I can provide you with translation certifications that you can use. And you really do want to be careful about what you post on social media. Immigration will be looking at accounts. I think that this is more so a factor for people who are coming over, people who are doing the process abroad, but it is always best to have a, you know, calm social media presence. So I wouldn't want any of you to, join, groups that might not look good, right? So we don't need to go into that because I know all of you have discretion. So obtaining evidence of any of your awards is always good. A lot of clients don't have a copy of their diploma in a PDF format. So if your PhD diploma is sitting on a mantle in your parents' house in Germany, ask them to take a picture of it and send it to you, because everything you submit to immigration does need to be in an 8x11 printed format. The USCIS has not started to, they're not accepting electronic cases yet. It is my hope that they will, really, because I don't believe in killing all of these trees to mail in a case that's going to be scanned anyway. But really, I would just say try to collect all the documentation that you would need to show your work in the field now, because having everything will be really helpful when you do start to compile your case. And approach your potential recommenders. You can send them an email saying, hey, happy December 1st. I just saw a presentation with a lawyer and I'm thinking of applying for my green card. Would you be willing to sign a letter on my behalf? And the last slide that I want to bring up before we open up Q&A would be having a birth certificate is vital to obtaining your green card. And so there is a reciprocity website that you can click on, and you can see if your birth certificate will serve the purposes of being appropriate for the green card. So really with that, these are really